so before I forget to do that. And now you're going to tell me if you see on screen a slide that at the top says rights of the criminally accused, requirement of due process of law. Okay, good. Thank you. All right, so one of the things that we've got to do, given what I just said about the intergovernmental, somebody might wonder, well, what in the world, we watched that program last time and it wasn't specific to Texas. In fact, they were talking a lot about provisions of the United States Constitution, specifically the Bill of Rights, the 4th, 5th, 6th Amendments. And we're talking about rules that have been developed by the United States Supreme Court. Okay, nothing really specific to Texas. So, it's kind of hard though for us to avoid in this discussion of criminal justice the effects that decisions of the federal courts, and particularly the United States Supreme Court, have had on criminal justice, and therefore the way that operates in Texas. It's kind of hard to deny the importance of these constitutional provisions. Okay, so that's actually where we're going to start. We're going to start talking a little bit initially here about, just so that we can sort of get everything straightened out. There was a lot of hinting around these in the program that we watched last time, but I want to get them out there in a systematic way so that everybody's clear what provisions of the Constitution that we're talking about that are relevant. Okay, so the 4th Amendment, and we're going to look at the specifics of each of these here in just a second, but the 4th Amendment generally is the amendment that deals with searches and seizures and the requirement for a search warrant. Okay, the 5th Amendment, and the 5th Amendment has quite about half dozen specific provisions in it, but specifically the provision against self-incrimination that we're going to be interested in exploring here in today's class meeting and then into next week. Okay, the 6th Amendment, which specifically deals with the right to counsel and the right to speedy, public, and impartial trial. The 8th Amendment, which prohibits cruel and unusual punishments and prohibits excessive bails and excessive fines. Okay, so these are the provisions of the Bill of Rights that are most relevant for us in our discussion of the criminal justice system as we go through that here today and, as I say, into next week. Don't worry, I'm going to move away from this particular slide, but I have a specific slide for each one of them, okay? Because I want to look at the language of each one of them with you before we get too far, and we'll come back to the 14th Amendment, okay? So the 4th Amendment, here's the actual language of the 4th Amendment. The right of the people to be secure in their persons, houses, papers, and effects against Sorry, it jumped on its own. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. That's the actual language of the 4th Amendment. Okay, so we'll get into the implications of that. Okay, the 5th Amendment reads, I said there's a bunch of stuff in here, and I'm not going to go through all of this. I'm going to just go right to the part that we're going to be interested in. Okay, it's the one that says, nor shall any person, right here, nor shall any person be compelled in any criminal case to be a witness against himself. And the 6th Amendment, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and assistance of counsel for his defense. Okay, so these are the those are the provisions that relate specifically to the right to counsel. Okay? And then the 8th Amendment, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Okay, give you a chance to process that, maybe jot down things that you think need to be jotted. And we're going to be returning to each of them, so you don't have to get everything down verbatim. All right. What I want to do before we sort of dive into the details of these is, talk a little bit about what I hinted at a moment ago. What does the Bill of Rights to the U.S. Constitution have to do with the criminal justice system in Texas? And I think a good starting point to address that question is to just remind ourselves of the timeline. Okay, so you'll recall that the U.S. Constitution was drafted in Philadelphia in the summer of 1787. September 17th, we celebrate September 17th as Constitution Day, because that's the day that the convention produced this document that we call the Constitution of the United States. Of course, it still had to be ratified by the states, and you don't have to know, I put this on here just sort of FYI, but here you can see the dates in which the states that were in existence at the time ratified the Constitution. The Constitution, of course, specified that it would take effect when 9 of the 13 states had ratified it, and I put a star there by New Hampshire because that was the 9th state. So it was with the ratification of the Constitution by the New Hampshire ratifying conventions in June of 1788 that the Constitution was approved. It was officially ratified. So it took about a year or so, really, to get all 13 of those original states to ratify the Constitution. Then when the first Congress met in 1789, over the course of that first year, Congress drafted 12 articles, submitted those to the states for ratification, 10 of which were ratified by the requisite number of states and took effect in 1791. And there you can see a list of the states and when they ratified the so-called Bill of Rights, the first 10 amendments to the Constitution. Interestingly, you can see that Massachusetts and Connecticut didn't ratify until the 1930s. Wow. But it didn't necessarily require those two states it only requires 3/4 of the states. Right? Okay, so one other thing I want to add to this timeline, okay? The 14th Amendment, which was drafted in the wake of the Civil War by Congress in 1866 and ratified on July 28, 1868. And there you see the language of at least Section 1. There are actually 5 sections of the 14th Amendment. Okay? The part of the 14th Amendment, Section 1, that we're interested in here is the part that says, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Believe it or not, that short little clause of the Constitution, it's hard to argue that there's any provision of the Constitution that has had more of a practical effect on our system than that one. Yes, sir.
So how does eminent domain relate to that?
Well, I'm going to postpone consideration of that question because, let me see if I can answer it very quickly. There is a provision in the Bill of Rights dealing with eminent domain. I forgot exactly what the wording is, but something like private property shall not be taken except with just compensation. So I'm not sure I guess I'm not sure exactly what your question is. How does it fit into the 14th Amendment?
Well, just how is it the state can't deprive any person of, for example, property?
without due process of law. It doesn't say nor shall any state deprive any person of property, period. It says nor shall any state deprive any person of property without due process of law. Yeah, no, okay, it's a good question. I just want to make sure I understood what the question was that you were asking. It's more clear to me now. So the eminent domain proceeding would qualify as due process of law. So if as a result of an eminent domain proceeding, government takes some private property for public use, assuming that they operated according to the established eminent domain procedures under state law and so on, then that would satisfy the due process requirement. Okay? But it's a very specific, narrow example of the broader point that really I want to try to get to here. The importance of the 14th Amendment it's hard to overstate the importance of this provision. There's also another part of the 14th Amendment which is arguably just as critical in our development of our system of law as the so-called due process clause. And that's the one that follows. That's the one that says, nor shall any state deprive any person within its jurisdiction the equal protection of the laws. But we're going to set that aside because it's not as relevant to the topic at hand that we're dealing with on criminal justice. Okay? And we'll come back and deal with it before we're done with this topic on criminal justice. But for now, I want to focus on the due process clause. Okay? So you've got this timeline, the Bill of Rights, which was drafted in 1789 and took effect in 1791. And then we jump way ahead 100 years to the 1860s, 1868 to be precise, and the 14th Amendment is added to the Constitution. But it really wasn't until the 20th century that the significance of the 14th Amendment began to emerge. Okay? 14th Amendment was ratified in 1868, but it really wasn't until the 20th century. So I'm taking just a few minutes here. Again, this is sort of an extended digression, but I got to lay the groundwork so that kind of everybody has a better understanding of why the provisions of the Bill of Rights are relevant to criminal justice in Texas. Okay? So it's pretty clear that the original intent of the Bill of Rights, what is the Bill of Rights? The first 10 amendments of the Constitution. Pretty clear that the original intent was to limit the power of the national government. That's why I'm going to go back here, okay? Look at the language of the First Amendment, okay? Begins, Congress shall make no law. It doesn't say Congress and state legislatures, Congress and city councils and state legislatures. It says Congress shall make no law. What shall Congress not make any law with respect to? Well, the establishment of religion, the free exercise of religion, abridging the freedom of speech, abridging the freedom of the press. I have that one highlighted because that was the provision of the Constitution that was relevant to the panel discussion that we watched on Tuesday when they were talking about the right of a fair trial and how that interacts with the right of the news media to cover all of the details of a trial, etc. Okay? But you're supposed to understand this phrase, Congress shall make no law, is not only implied with each of these clauses of the First Amendment. Congress shall make no law respecting the establishment of religion. Congress shall make no law prohibiting the free exercise of religion. Congress shall make no law abridging the freedom of speech. Congress shall make no law abridging the freedom of the press. Congress shall make no law abridging the right of the people peaceably to assemble. Congress shall make no law abridging the right of the people to petition government for redress of grievances. But you're also supposed to understand that is implied with each successive provision of the Bill of Rights. So if we go to the Second Amendment, the right of the people to keep and bear arms, you're supposed to understand that that is intended to read, Congress shall make no law abridging the right of the people to keep and bear arms. And if you go to the Fourth Amendment about searches and seizures, Congress shall make no law abridging the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Do you understand what I'm saying? What the logic of the Bill of Rights is as it pertains to the limitation on the power of government. Its original intent was to limit the power of the national government. And that's why they very deliberately put the word Congress there. Another bit of evidence to support that is that in some original drafts of amendments that were submitted to Congress in 1789, that first Congress, there were provisions that would have limited states, but they were worked out. They were taken out. Okay? So there's no question, it is very clear that the original purpose of the Bill of Rights was to limit the authority of the national government. Well, one may ask, given that, if my rights of free speech, if my rights of free worship, if my right to be secure against unreasonable searches and seizures is protected against the authority of the national government, okay, by the Bill of Rights, what protects my right of free speech, or what protects my right of free worship, or what protects my right of privacy in my home against the authority of states? Well, the logic, the prevailing argument of the time was that that was the function of state constitutions. And in fact, state constitutions do, as the Texas Constitution does, we pointed out earlier in the semester when we dealt with the topic on the Texas Constitution, does have a Bill of Rights. Why do we need both? Well, in its origins, the Bill of Rights to the U.S. Constitution was only intended to limit and protect your rights against the authority of the national government. So if your rights are also going to be protected against the authority of the state governments, then you're going to have provisions in state constitutions limiting the state government's authority to abridge your liberties. Does that make sense? Straightforward enough? Okay? The problem with that reasoning was that state governments routinely disregarded those provisions of their own constitutions. For example, there were a number of states that had, despite provisions in their state constitutions prohibiting establishment of religion, there were several states that had official religions. Did you know that? Does that shock you as an American to learn that as late as the 1830s, Massachusetts had an official religion, Congregational Church?
Like, if you were caught not,
I'm just saying it was the officially sanctioned
religion.
church of Massachusetts.
Yeah.
The days of punishing people for not attending services ended during the colonial period. Although that surprises some Americans to learn that about their history, because a lot of Americans assume that the so-called pilgrims that came to Plymouth Colony and, of course, Massachusetts Bay Colony were all about freedom of religion. But they were probably the worst persecutors of religious dissenters one could imagine in the American experience.
Yeah,
The Puritans, so-called
Puritans were
Puritans.
kind of kicked out of every other country they were in because they were so extreme.
I don't want to digress too much on that point. Really, the broader point I'm trying to make is that that's just one example. I'll give you another example of how states disregarded their own provisions of their own constitutions in the area of civil liberties, freedoms. In southern states, down to the Civil War, it was illegal, freedom of the press notwithstanding, it was illegal to publish abolitionist literature, despite the fact that most of those states had provisions of their state constitutions that protected the freedom of the press. Okay, so that's the basic problem that we're facing. In the 19th century, down to the Civil War, you may have had bills of rights and state constitutions, but effectually they weren't observed. Okay, so after the Civil War, the 14th Amendment is added to the Constitution, but as I said, it's really not until the beginning of the 20th century that it begins to have any practical effect. During the 20th century, beginning in the early part of the 20th century, the United States Supreme Court began to incorporate on a selective basis specific civil liberties rights in the Bill of Rights, beginning with the right of free speech, and the right to peaceably assemble, the right of free worship, and so on. began to incorporate those civil liberties rights into the concept of liberty that is protected against state authority by the 14th Amendment. Okay, so for example, I'm not going to go back to the entire 14th Amendment, but you can see the relevant clause here. It's the one that says, nor shall any state, so that includes Texas, or Louisiana, or Idaho, or Maine, or Vermont, or any other state, nor shall any state deprive any person of liberty without due process of law. So the question then becomes, well, what does the concept of liberty incorporate? What does the concept of liberty include? Does it include the right of free speech? The Supreme Court of the United States has said yes. That's a fundamental right of the individual. That's a fundamental freedom of the individual. As it is embodied in the First Amendment and protected against the national government's authority by the First Amendment, it is incorporated into this concept of liberty embodied in the 14th Amendment and protected against the authority of the state, and by virtue of the state, the authority of local governments as well. Because remember, local governments, as we've recently learned, are creations of states. So is your First Amendment right of free speech protected against the authority of the city of Sugar Land? Well, framing it that broadly, yes. Okay, does it mean you can say anything you want, anytime you want, under any circumstances you want? We'll come back to that. Okay, the city of Sugar Land police officer, if you go down to town center and you draw attention to yourself somehow, and you are hurling all these explicatives, dropping all kinds of F-bombs and so on, and a city of Sugar Land police officer comes and slaps a citation on you, or even better, places you under arrest for violating local obscenity code, and you say, wait a minute, I've taken Fagan's government course. I know that the right of free speech, as protected against national authority by the First Amendment of the Constitution, has been incorporated by the United States Supreme Court to protect my right of free speech against the authority of the state of Texas and therefore the city of Sugar Land. Therefore, you cannot place me under arrest. You have no. Well, you can make that argument if you want to. We'll see how it comes out in court. I have a prediction for you. You're not going to prevail. Because the courts, we'll get to that in some detail here in just a second, but the courts have never really said that the right of free speech means that you can say anything you want to, anytime you want to, under any circumstances that you want to. For now, though, let's just focus on this idea of incorporating a specific civil liberties right. Okay? Because the 14th Amendment is vague, it doesn't say specifically what does liberty include. That means that somebody is going to have to tell us what the concept of liberty includes. And that, for better or worse, depending on your political ideology or your philosophy, has been the courts. Been the role of the courts to tell us what this concept of liberty includes or incorporates. Okay? All right, so the bottom line, in terms of the setup that we're trying to get to here, is that since the beginning of the 20th century, the United States Supreme Court has selectively incorporated some, but not all, of the provisions of the Bill of Rights into the 14th Amendment's concept of liberty. It has incorporated all of the First Amendment freedoms, the right of free worship, the right of free speech, the right to peaceably assemble. Everything that's in the First Amendment, the court has at some point said that's a fundamental right of the individual and therefore protected against the authority of the states through the 14th Amendment. But there are others that the court has refrained from incorporating, like the Third Amendment quartering of soldiers. And I think that's really simply explained by the fact that it's a moot question. Right? The United States military is not going to come knock on your door and say, get out, we got to move a platoon in. Is that a unit of military organization? Would that fit in a half?
Yeah.
Right. Okay, yeah. They're not in it. It's a professional military. They've got their own housing for their own, for soldiers, right? But the historical origins of the Third Amendment are important, right? Because that was the practice of the British during the colonial period. It has never incorporated the Fifth Amendment, or at least not yet, the Fifth Amendment provision for indictment by grand jury. I think we may have touched on this point earlier in the semester when we talked about the Texas Constitution. It really just depends on which state you live, whether that right to indictment by grand jury is protected. Is it protected by the state constitution? Because the Supreme Court has never incorporated that as a fundamental right of the individual. I used to include the Eighth Amendment provision against excessive fines in that list. But notice I've lined through that. I've had to go in and update the slide because fairly recently the United States Supreme Court incorporated that in a very interesting case involving, I believe, a case that came out of the state of Indiana involving an individual who'd been accused of drug trafficking, as I remember, and had his Hummer or some kind of very expensive vehicle confiscated by the police. And you know what they do, what police departments do when they confiscate, personal property and raids like that, right? They either use it themselves or they sell it off and use the proceeds, right, to raise money for the department. This guy had claimed that he was being deprived of his property. He had an excessive fine imposed on him, and the Supreme Court agreed and said that is, incorporated in the 14th Amendment. Up until 2010, I used to include the Second Amendment in that list of amendments that the Supreme Court had refrained from incorporating. Because it wasn't until 2010 that the Supreme Court did that. It's only been about the last decade or so, 10, 11 years. Actually, the process began in 2008 with that D.C. case, District of Columbia versus Heller. That was the first time that the Supreme Court had ever said that the right to keep and bear arms is a right of the individual. We had for many decades a debate in this country about whether the Second Amendment right to keep and bear arms, the right of the people to keep and bear arms, was an individual right or a collective right. Obviously, gun owners, gun rights activists are universally going to take the position that that's a right of the individual. Gun control advocates, people who want to place restrictions on gun ownership and the proliferation of guns in our society, were more likely to argue it's not a right of the individual, it's a right of the community. Because they would say that gun control or gun rights advocates conveniently forget about that other piece of the Second Amendment that says a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. They would say, who's going to regulate the militia if not the state? So therefore, in their view, the conclusion was, and again, I don't want to digress too much into a discussion of gun owners' rights or gun control. That's really not the point of this whole discussion, okay? My point was that was the first time that the Supreme Court in 2008 had clarified, because for many decades they had refused to take up a case and make that decision, leaving many people to conclude that the Supreme Court was saying it's up to the states to decide the extent to which they want to regulate firearms. But in 2008, they said no, because the District of Columbia had an ordinance, a local law, that prohibited the possession of any firearm that was assembled and capable of firing. I don't know if you're aware of this, but in the nation's capital, they've had a crime problem for many, many, many decades. A very severe crime problem and gun-related crime problem. So their solution was, at least part of their solution was, to just make it illegal for people to have firearms in the district. But the Supreme Court said no in 2008. Now, I didn't completely answer the question, though, because, as you all know, District of Columbia, at least not yet, is not a state. Right? It's a federal city. And so, presumably, the Second Amendment, which is directed at the power of the national government, would apply to the District of Columbia. Congress shall make no law abridging the right of the people to keep and bear arms. Okay? But what about in Illinois or some other state? Well, the Supreme Court answered that question a couple of years later, in this case, McDonald versus Chicago. And that was the first time that the Supreme Court said, not only is it a right of the individual, but it is a right of the individual that is a fundamental right and therefore incorporated into this concept of liberty and protected against the authority of the state by virtue of the 14th Amendment. So what the 14th Amendment reads in effect is in this particular instance, nor shall any state, that would include Illinois, nor shall any state deprive any person of the right to keep and bear arms without due process of law. You understand how any one of those specific civil liberties rights has been taken up by the court, and you can plug it in. Nor shall any state deprive any person of the right of free speech without due process of law. Nor shall any state deprive any person of the right of free worship without due process of law. Nor shall any state deprive any person of the right to counsel without due process of law. Nor shall any state force a person to be a witness against himself, etc. Right? Those are the ones that we want to focus on. But again, I'm just trying to get you to understand the importance. It's hard to overstate the significance, the importance of this 14th Amendment due process clause. That's why I'm hammering on it. I want to make sure that everyone is clear. Any questions? Any questions about the doctrine of selective incorporation? It is not the doctrine of total incorporation. Why is it not the doctrine of total incorporation? Well, because the Supreme Court has never said that everything in the Bill of Rights is protected against the authority of the states through the 14th Amendment due process clause. It's done it on a case-by-case, provision-by-provision basis. That's what the doctrine of selective incorporation means. Now, I understand this is not a law school course, but this is such an important component of our law, and particularly as it pertains to the criminal justice system, that I just don't think that we can gloss over it or ignore it. Certainly, we have to understand why the federal courts, and particularly the United States Supreme Court, have played such an important role in the criminal justice system as it applies to Texas or any other state. And the 14th Amendment is a big part of that. Okay, there's one other issue I want to touch on before we get to the details of the criminal justice provisions. Okay, a general issue here. Okay, with any of these civil liberties rights that we might talk about, whether it's the right of free speech, or the right of free worship, or the right to counsel, or the right to keep and bear arms, or whatever the issue is, it's always a matter of line drawing. None of these civil liberties rights have ever been recognized by the courts, the United States Supreme Court in particular, as being absolute. The right of free speech is not an absolute right. You can't say anything you want, anytime you want, under any circumstances you want. The right of free worship is not absolute. You can't do anything you want in the name of your religion, even if it violates federal or state or local law, and claim that you can't touch me because I have a right of free worship. Yes, sir.
And like I'm just watching from like the back, and like watching like everything play out in the way like how everything's going today. But there's one thing that I will say like that I saw recently that I like have watched to make sure it's factual. So our president did say that no amendment is absolute.
You had a conversation about this with one of your classmates after Tuesday's class meeting. And I told your classmate that I had not heard President Biden make that remark. I hadn't read anything about it, but I had been pretty immersed in other things, okay? And I still haven't, I'm still immersed in other things, and I haven't really gone out to read any news accounts. But I'll share with you what I shared with your classmate, okay? Bearing in mind that I am willing to admit that I could be wrong about this,
Yeah.
okay?
Like,
But I suspect that the president, Mr. Biden, misspoke. What he really meant to say was that none of the civil liberties rights in those amendments that are embodied in those amendments have ever been considered to be absolute. Okay? Now, obviously, Mr. Biden's critics, Mr. Biden's opponents are going to jump on that, right? And maybe that's fair, right? Maybe the president should be more careful about his word choice, right? I do know, and again, I shared this with your classmate, that I have some sympathy for Mr. Biden. I don't necessarily consider myself a Biden supporter, but I have some sympathy with him as a human being because I'm not sure if you're aware of this. He has struggled with a lifelong stuttering problem.
yeah.
I've known people very close to me in my life who have struggled into their adulthood with stuttering, and it can be a real challenge to divert your mental energies when you're trying to not stutter to necessarily pick the right word in a particular circumstance. And I think that there's a chance that that's what happened to Mr. Biden. He may just be misinformed, right? Maybe he got that line from an aide, right? And he didn't think about it very carefully, or they didn't analyze it very carefully. But what I think is more likely is that he just misspoke, and what he meant to say was that the right of free speech has never been considered an absolute right. The right to peaceably assemble has never been considered an absolute right. The right to keep and bear arms, which is, I think, what motivated the comment, I think he was probably trying to say, should not be treated any differently than the right of free speech. It's not somehow sacrosanct, and that we should treat it somehow as an absolute right where the government, or more generally that we as a civilized society, don't have some interest in imposing reasonable restrictions on the exercise of that right. We can, as a civilized society, impose reasonable restrictions on people's exercise of their religious faith.
Yeah.
The First Amendment says that Congress shall make no law prohibiting the free exercise of religion, but that doesn't mean you can do anything you want in the name of your religion.
Yeah.
I mean, the obvious example, you can't practice human sacrifice.
Yeah.
And then when the police come and arrest you for murder, say, oh, I have a right under the First Amendment to freely exercise my religious faith. You can make that argument all day long as much as you want, but you're not going to prevail, I'm pretty confident. Right? By the same token, as I always like to say, you can't drive through a residential neighborhood at 3 a.m., blaring some message over a public address system, waking up all the neighbors and whipping the dogs into a frenzy, and when the police blaring some message, and when the police come and arrest you for disturbing the peace, say, hold on a second, I've got a right under the First Amendment of free speech. Again, you can make that argument all day long, but we have always recognized as a civilized society that that the government can impose at a minimum time, manner, and place restrictions on the right of free speech. And not only time, manner, and place restrictions, but there are certain types of speech that aren't protected. We know, I hinted out a few minutes ago, obscenity is not protected speech. You can't use obscene speech and expect not to be prosecuted. You can't libel someone. You can't slander someone and use the First Amendment as protection. Fighting words are not protected speech. How do we know this? Well, because the courts have told us. Fighting words are not protected. Libel, you can't libel, so you can't defame someone and damage their reputation and all that goes with that and claim the protection of the First Amendment. So if the First Amendment right of free speech is not absolute, and that as a society we can impose reasonable restrictions on that, I suspect that the president was wondering out loud, or asserting, I guess is a better choice of words, asserting that it is also possible then for the government to impose reasonable restrictions on the right to keep and bear arms. Again, I could be wrong. I could have that entirely wrong, but I suspect that's what motivated the whole episode.
I was just asking just because we were talking about it.
Yeah.
And talking about the whole
Yeah, I understand.
Yeah.
I think he uttered the word amendment, but he would have been better advised to utter the words
Look at the
civil
video.
liberties rights.
Yeah, look at the video for me and then,
Okay. Yeah, when I can get around to it, I plan on looking at it because, as I said, I've already had this conversation with the classroom. Okay, so that particular point about Biden aside, the broader point that I'm trying to make here is that it's always a matter of line drawing, whether we're talking about the right of free speech or the right of free worship or any of these other civil liberties rights, where you have, on the one hand, the right of the individual, perceived right of the individual, right? And then on the other hand, you have the state, and I'm using that term state here very broadly just to mean the authoritative nature, the authoritative aspect of society, the ability of society to authoritatively make rules and regulations. So it can be the national government, it can be the state government, it can be the local government, right? Or the community, right? Does the community have a compelling interest here? Okay? And then it is a matter of determining where the line should be drawn between the right of the individual on the one hand and the interest that the community is asserting on the other hand. Okay? Because when the community passes a law regulating speech or regulating gun possession or regulating public demonstrations or whatever the case is, it is invariably going to be asserting some interest. The reason that we're doing this is because we're trying to prevent some substantive evil, right? Does the community have an interest in promoting stable civil society, for lack of a more general way to put it? Yeah, of course. Is that interest that the community has in that common objective compelling enough to warrant intrusion into the individual's right? That's the question, the practical question that the courts then end up taking up as a matter of line drawing. I've drawn this line as a broken line because I'm trying to suggest to you that it is not clear. It is not clear in any of these areas. It's not clear in any of these areas for all time where the line is to be drawn. Okay? So we really just kind of have to take it on a case-by-case basis. But what we can say is that in most scenarios, in most of the cases that arise, it is the burden of the government, whether it's the national government or the state government or the local government, to establish why its interest is compelling enough to warrant the restriction of the individual's civil liberty right. What is at stake here? What is so important? What is so important to the community here that justifies curbing the individual's right of free speech or the individual's right to keep and bear arms or whatever the specific civil liberties right is that we're talking about?
It could be like the rights of the other citizens. If they're being offended by this person using their right to negatively affect their rights.
Yeah, I mean, I think that's one very general approach that the government is going to try to take, that the individual's right to enjoy his right of free speech or whatever the specific right is only goes so far as it doesn't infringe on other people's rights. Okay, so that's a very general consideration. But oftentimes when we take up these, when the courts, I say we, when the courts take up these specific cases, they are looking to the specifics. They're not looking to that general. They're looking to say, in this specific instance, this law that the local government has passed or the state has passed, which clearly restricts free speech rights or clearly restricts gun ownership rights, is the interest that it's asserting compelling enough to warrant or justify that restriction of individual liberty. And the reason, by the way, just to go one last time to the gun rights thing, the reason that we have less certainty in the area of the Second Amendment than we do, for example, in the area of the First Amendment, some of the other civil liberties rights, is because it's so new. Okay? It's taken decades to work out where the line is drawn in the right of free speech and some of these other areas. It's only been 10 years since the court handed down that decision in that Illinois case. So I suspect that in the years to come, in the decades to come, as California or New York or Massachusetts or whatever other state passes laws trying to restrict access to firearms, and those get challenged in court, and some of them make their way up to the United States Supreme Court, it's going to just take some time for the court to work out all those details. There's very rarely in any of these areas sort of a overarching decision of the court where we can just say, you know, in every instance, this is how the law is going to apply. I can't think of any example in any of these civil liberties areas. Okay? So we've got two things sort of of general nature that you got to keep in mind as we work through these criminal justice issues. The first is that the Bill of Rights has been selectively incorporated, and that includes the specific amendments that we're talking about, the 4th, 5th, 6th, and 8th Amendments. Okay? Even though in my examples here we focused on the First Amendment and the Second Amendment, those aren't as relevant to criminal justice as we need to get into. Okay? So that's the first thing, this doctrine of selective incorporation, and certainly for no other reason for the purposes of a quiz, you need to know what the doctrine of selective incorporation is about. And then the second matter is this matter of line drawing. Okay? It's always a matter of line drawing in an attempt on the part of the courts in saying what the right of free speech or the right of free worship or the right to keep and bear arms or whatever the specific right is, in saying what it means or what that provision of the Constitution protects. It is a matter of trying to balance the interests of the community against the rights of the individual, determining where that line is drawn. Okay, questions about either of those points? Okay, so let's go back to, we only have about 13 minutes remaining in today's class meeting, but we can at least get started on this and then we'll get into it heavy next week. Okay, what?
We talked about the video.
Yeah. I mean, we sort of started with that video last time, introducing you to some of these things. So this is not going to be new. It's not going to be like you haven't heard of these things before. But now we're going to get into some of the details. Okay. All right. So I want to begin by talking about this exclusionary rule that they were dealing with in that program last time. And you may remember at one point when they went away from the panel discussion to Justice Potter Stewart. By the way, former Supreme Court Justice Potter Stewart. I told you that there were a lot of heavy hitters on that program. Obviously, Potter Stewart would be one of them. But the guy who was talking to him, who was sort of running, his name is Fred Friendly. And if you've never heard the name Fred Friendly before, if any of you decide to go into broadcast journalism, you should know the name Fred Friendly. Fred Friendly is a pioneer of broadcast journalism. It was actually portrayed by George Clooney in a movie a few years ago. George Clooney was Fred. Can you believe that guy George Clooney turns out to look like Fred Friendly?
Which one was that?
Fred Friendly, the guy who kind of looked like the Muppet. You know, was the older gentleman who was talking to Potter Stewart, asking Potter Stewart.
At the table?
Yeah,
Oh, okay.
yeah.
Oh,
I'm just saying he was a pretty big deal in broadcast journalism. He's deceased now, but he was a pretty big deal. At any rate, there was a point in the discussion between those two gentlemen where Potter Stewart said a decision of the Supreme Court almost 70 years ago. Well, remember that program is now 40 years old, right? So we're talking about over 100 years ago. The precedent-setting case, as it pertains to the exclusionary rule, actually goes back to 1914. This case, Weeks versus the United States. That was the initial case where the Supreme Court held that evidence found by the police in violation of the Fourth Amendment provision against unreasonable searches and seizures could not be used in court to obtain a conviction against the defendant. Now that case, that Weeks case, involved federal law enforcement. I believe, if I remember correctly, I really need to go back and refresh my memory on this particular case. If I remember correctly, it involved a guy who had been selling lottery tickets to the United States mail, which was a federal crime. And therefore, he was prosecuted by federal law enforcement and convicted in federal court. But in the process of all that, he had some of his property confiscated by federal law enforcement, and he claimed that it was an unreasonable seizure, and the Supreme Court agreed. And furthermore, held that the evidence that the police obtained through this unwarranted seizure, this illegal seizure, was not admissible at court to obtain a conviction against Mr. Weeks. Okay? So initially, that's why this case is important. That's the case that Potter Stewart was referring to when he said almost 70 years ago. And remember, he said, not a snivelingly liberal court. I think that's a hilarious expression. As if somehow, if you're liberal, you must be sniveling. Not a snivelingly liberal court either. It was a court that was relatively conservative, he says, that handed down this decision that said that the government can't use the evidence in an illegal search and seizure against the defendant. Okay, so that's the origins, that's the birth of the exclusionary rule. Now, that was a case involving federal law and federal law enforcement. Okay, and remember that the Bill of Rights, and that includes the Fourth Amendment provision against illegal searches and seizures, unreasonable searches and seizures, originally applied only to the federal government. It didn't apply to states. It took another 50 years, okay, for the United States Supreme Court to say that that right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures is also protected against the authority of state and local law enforcement. And that happened in a case called Mapp versus Ohio. We don't have to get too much into the weeds with these cases, but I think this one is interesting. Have any of you ever heard of this case before? This case involved a woman named Dolry Mapp in, I believe, Cleveland, Ohio, one of the major cities in Ohio anyway, who the police arrived at her home with a search warrant that indicated that they were looking for evidence in a bombing incident. And they executed the search. They didn't find any evidence related to a bombing incident, but they did find materials that they deemed under Ohio law to be obscene. And so they arrested Mrs. Mapp for violating Ohio obscenity laws. She was convicted and given a sentence, and she appealed her conviction on the grounds that it violated the Fourth Amendment's provision against unreasonable searches and seizures. Remember that the Fourth Amendment says something about, go back to it here real quick. It says something about, I said 14th Amendment, I meant 4th, okay? It says something about describing the place to be searched and the person or things to be seized.
So you can't just go in there looking for one thing and grab another thing.
I was going to ask you that question, right? Why do you think the framers of the Bill of Rights had in mind there. And, I mean, it's so long ago, could they possibly anticipated these kinds of circumstances? But I think you're on the right track, right? That this is really intended to prevent the government and its police power from going on what we might call today a fishing expedition. Let's just go in and look and find something, right, against this person, right? So the search warrant is supposed to specify what they're looking for, what they expect to find. And in order to get that warrant, the judge is going to have to make a determination. They're supposed to have to convince the judge who issues the warrant that there is a reasonable probability that they're going to find what they say that they're looking for. And if the judge doesn't believe that they're not going to do it, they're not supposed to issue the warrant.
So that could be used for people a lot from maybe if a cop wanted to incriminate someone using fake evidence.
That is true.
Things.
They could just.
Well, maybe, but
No, you have to convince that there's a judgment, there's a reasonable reason that person would have that, and if they don't.
yeah, but remember, we're talking about physical evidence here. When the police do a search, we're not talking yet about statements. We're talking about the police going into, in this case, a private home and looking for physical evidence in a particular criminal act and not finding it, but then finding something that they could use against her.
So in the case of that video with the shrine and the rose, which is rosary on the shrine.
So you have to basically be very specific when you get your warrant. Like, this is what we're going to look for.
I'm not a lawyer. I always have to preface what I'm saying. I'm not a defense lawyer. I'm not a prosecutor. I don't have the kind of background. I'm not even sure that there would be a consensus, though, among those who do have law backgrounds. I think it's very murky. But, again, I think that's why I said earlier that these things tend to get worked out on a case-by-case basis. Maybe deliberately or not deliberately, the police push the envelope, right? And then it has to be tested. It amounts to a test case. Oh, well, we've never dealt with this question before, right? Maybe they obtain a conviction. Maybe they execute this warrant, and there's some issue that the defense wants to, hey, that's a violation of the provision. It should have been excluded at trial. It's just hard to say. You kind of have to work these things out, individually. Now, you heard in the credits, as the credits were rolling, in fact, I drew your attention to the fact that that year, 1984, represents something of a point of departure, because when they produced that program, like they filmed the roundtable discussion, there was a pretty widespread consensus among the people around the table about how the exclusionary rule would be applied as a prophylactic and sort of a mechanical application of the exclusionary rule. Maybe you remember some of that discussion, right? Many of the participants were saying that some were opposed to it. Some were saying it needed to be changed, but there was pretty much universal agreement around the table that given the hypothetical circumstances that the moderator described, that hypothetical crime, that the evidence should be excluded, that the judge should say it should be. Remember how they all pretty much said, no, of course it should be excluded, right? But then the footnotes indicated that, well, the most recent decisions of the Supreme Court in 1984 at that time suggested that maybe there was changes in the wind, okay? And so I want to talk a little bit about these exceptions to the exclusionary rule, okay? So notice the year here, 1984, a case called U.S. versus Leon, in which, I don't want to get too much into the details of these cases, but this case involved a man by the name of Alberto Leon, I think his first name was Alberto, in California, who was being surveilled by local law enforcement, suspected in drug trafficking. Right? And The police went through the process of getting the search warrant, okay? And the judge signed off on the warrant, okay? And they executed the search warrant, and they found evidence, and they put him on trial, and he was convicted on the basis of that evidence. However, on appeal, the counsel for Alberto Leon argued that the warrant was defective because the judge, or more precisely the administrative staff of the judge who signed off on the warrant, had failed to correctly specify a number of details in the warrant. Okay. And so that, on that basis, Leon's lawyers argued that the evidence should have been suppressed at trial and the conviction should be reversed. But the Supreme Court of the United States disagreed, holding that it was a good faith exception, okay, that the police had executed the warrant, believing it to be valid. We'll end on this point, okay? The police had executed the warrant. At the time that they executed the warrant, they believed the warrant to be valid. And the whole purpose of the exclusionary rule, the Supreme Court argued, is to prevent the police from flouting the provisions of the Fourth Amendment. It's not to punish the police for the mistake of the judge or the judge's administrative staff. The police executed the warrant in good faith. So if the warrant is executed in good faith, then any evidence that's obtained that, you know, might not have been specified in the warrant, or details that might not have been specified in warrant, do not necessarily have to be suppressed at trial. You see, before 1984, it would have been automatic. It's going to be suppressed. Okay? But now the court is going to, essentially what the court's saying is, let's look at the specifics. Look at the specifics and see if it is really the kind of issue that would warrant a suppression in this case. Okay? So that's the first, salvos. In 1984, we're going to see a bunch more of them, okay? Where as I described last time, where the pendulum begins to swing back in favor of law enforcement through the rest of the 1980s and the 1990s and now even into the 2000s. Okay, we'll see you on Tuesday.